Thank you, Your Honor. May it please the court.
Thank you very much for your patience and for your attention for the next, hopefully, 45 minutes to an hour. I know all of you come from different work settings, employment backgrounds. And you are familiar with what's required for you every day. You know it because you live it. You know what's important when you get up in the morning, what you do at work in your career, what's expected of you. And some of you are bosses, supervisors, own your own business. You have that perspective. And you bring it into this courtroom and you're told you're sitting on a case about a breach of public trust and stealing state funds. And you hear from an elected district attorney who's resigned, who has pled guilty to a misdemeanor and told you a bunch of stuff. So it just doesn't make sense that this other elected district attorney pleads not guilty, facing 6 felonies and a misdemeanor. And what also doesn't make sense is that after the state makes their opening statement and puts on their evidence, the defendant doesn't put on evidence. Why? Why is that the case? When the opening statement was a forecast of the district attorney's office for the first 4 years, the first 2 years of this incident, and the whole truth of what happened. Why? Because that didn't happen from the state's evidence, and a principle that you agreed to follow from the very beginning as a juror. This case is about oaths, and you will judge my conduct based on my oath. That you would follow the law. You know what one of those laws is? The defendant is presumed innocent. As you sit there right now, do you have that in your heart? Do you still presume the defendant is innocent? Or, as you sit here as jurors under an oath, feel some tug that maybe you presume guilt? Do you already believe and concluded that there was an obstruction of justice, and another obstruction of justice, and another obstruction of justice, and a conspiracy and an intent to defraud state monies right now? Well, if the state has the burden of proof, and the investigation has the duty to seek the truth, then where are we? I told you in the beginning that this was about a bigger truth than what's alleged between April 1st and October 24th. It's not a narrow, this person working and submitting hours and obstruction of justice. The bigger truth is this: how we make felons in North Carolina. How does our system of investigating crimes and prosecuting people all across North Carolina create that convicted felon? And unfortunately, it starts just like this case. A discovery that says this investigation started April 6th, 2016 with Jason Ramey meeting with an officer to set out 3 issues. But after the investigation and charges, with digging from the defense, what do you know? Started in December of 2015. Jason Ramey talked to somebody else, another SBI agent. Do you know what they said? No. Do you know what they did? No. If any of you were charged with a crime that started April 1st, and there was an investigation or a report 4 months earlier, you weren't watering your law and right. Let's make it simple. You're supposedly not doing something right. And 4 months earlier, law enforcement is aware of this, and you're not contacted, it's not addressed, whatever. What's going on? In fact, why do we have a citizen jury? So that you as citizens can look at it from the defendant's perspective. How about this? You're the one accused, and the person accusing you sits down with the officer and says 3 things bad about you. And one of them is just a lie. You haven't heard any evidence that Jason Ramey was charged with obstruction of justice by claiming Tyler Henderson was getting a full-time paycheck from Rockingham while going to law school. Is that okay? Oh well, I know I said it about you, but it wasn't true. As we work through this case, I want you to consider this. Right now, do you presume that Cindy Blitzer didn't work from April 1st to October 24th? And what is the evidence of that? She said so. And the state, in their carefully, surgically presented case, wants you to believe that. Because she said so. On the other hand, they want you to vote guilty against me because Cindy Blitzer, after being told you have to put your hours in the beacon system, represented, I work those hours. So believe the state when Cindy Blitzer said I wasn't working. Don't believe Wallace Bradsher when he's pled not guilty about this representation that she was working. How do you get to the truth? It's an interesting phenomenon. Young mother brings in her son whose laptop stolen. I want justice. We saved up all our money to get this laptop. This other young man stole it. I want him convicted. I want him to go to jail. A year later, her son is accused of stealing a four-wheeler. And she says, look, he didn't do it. I know these other people said he did it, but he didn't. I don't want my son to be convicted of a felony. Same mother, 2 different perspectives, wants justice. So let me ask you this. If you were facing charges, wouldn't you want law enforcement to document all the story, all the evidence, not just what they deemed appropriate? So where do we go? We have this inquiry in April, and then by August, there's this investigation. And what does Agent Whitley do? He calls me August 10th. He tells you that. He interviews me September 6th. He talks to me October 6th. He interviews 2 folks from Rockingham August 29th. He interviews members of my staff. He goes to Rockingham, interviews members of their staff. ADA Ramey, I had him refresh his memory. 8 times he talks to ADA Ramey over a course of 2 months. He's doing all of these investigations. And you're being asked now, based on what the state has presented, to conclude that I'm guilty of these crimes. How many of those interviews and people have you seen? Really? They put on someone from AOC to say Cindy got paid. They put in Beacon. They put in Cindy Blitzer and Craig Blitzer. Put on Gail P., Tyler Henderson, Jay Stoltz. What about the AA in Rockingham? where Cindy Blitzer's office is, where the key card entries, even after April 1st, existed, where I asked Ms. Blitzer, isn't it true you tried to put in your beacon hours October 6th? And isn't it true you told Melinda Richardson that you were working and that you had stuff that you took on? No, I don't remember that. Agent Whitley, didn't you interview Melinda Richardson about that? Yes. What's the answer to that question? What did she say? And if Cindy Blitzer was doing that and making that representation, isn't that something that you should have from the state to support their position that I'm guilty of these crimes? How about this? The allegation is, because Cindy said so, that she didn't work at all from April 1st to October 24th. They went and seized a computer designated as Cindy Blitzer's computer, which the agent said last activity October 6th, 2016, to forensically test it to see if what had been done and when it was done. And did you hear the agent's answer? And would anybody in this room or their sons or daughters want them to face a felony when the officer investigating says, our main witness, who didn't get charged with anything, who allegedly worked all these months and got a paycheck, said she didn't work? And we believe. So we have evidence of her computer, but we decided we just won't test it. Why? The bigger truth. This cannot continue to happen in North Carolina, where law enforcement chooses not to test physical evidence because it might reveal evidence that says their witness is lying? Is that what we have come to in our Twitter, Facebook, computer age, where we want to make decisions like that? That evidence may hurt our witness. That evidence may interrupt or conflict with our version of the truth. So it's okay? What if in Hickory there's evidence Cindy Blitzer worked during this time period that I'm charged with? Does that matter? Should the state have put that on? And what in the world was going on in Rockingham County? I think it's important, and I ask you as jurors, to look at it in a sequence of events. It's easy to look at Craig and Cindy Blitzer now and all that they have admitted to and said they did, but all that was as of May of 2017. Take you back in time. Are there people in your life you trust? Are there people in your life that you work with that, barring some other information, you rely on what they say? Think about that for a moment. So the evidence from the state is March. I go over to get the Shockley file. Now, part of your evaluation of this case is based on reasonable doubt. All that is if you have a doubt based on reason, common sense, based on not just evidence you see, but the lack or insufficiency thereof, like that computer in Hickory that's still not tested. Now think about this in terms of reason and common sense. We're in Rockingham, getting a murder case. It's being transitioned. Tyler Henderson's there. Another legal assistant's there, Cindy Blitzer's there. And the allegation is that another elected DA says to me, hey, I heard there was an FBI investigation about Cindy Blitzer's working. And the state wants you to think that I just said, oh, well, no problem. Doesn't bother me at all. This elected DA in the second term with a wife and family, you know, that I just blew it off. They also want you to believe I took the Shockley file thinking she didn't have any work to do, while I've been told there's an FBI investigation. Does that not defy logic? I must be the dumbest criminal in the world. And then a few weeks later, I'm going to an elected DA's conference in Oakwood with a bunch of other elected DAs, and this elected DA in my adjoining district supposedly says in a car in the driveway, oh, Cindy doesn't have work to do. What? You mean Cindy? The one the SBI may be investigating? Let me just ignore that. Let me just say, oh, well, she can just focus on her schoolwork. And this same reliable witness that you heard from told you that in June, he was told again that there was an FBI investigation to such an extent he went and saw a lawyer? But he didn't call me? This same elected DA says when he learns about this FBI investigation in the fall, well, Attorney Grace is not really my lawyer because, you know, he was Cindy's. Did you hear him say that? And then Cindy testified. I didn't have a lawyer. I didn't have a lawyer till spring of 2017. Zatarsky. What is going on here? Truth. Truth. Now, I can't stand before you and tell you the evidence reflects that I was a great manager. As an elected DA, if I sat in an office and just was an administrator, I contend to you this wouldn't happen. But what you heard was, when the SBI called the first time, where was I? In a jury trial. Have you heard any evidence from the state that Pam, my wife, didn't work and didn't work hard, or that I didn't work or work hard? I understand the arrangement is easy for the state to wave the flag and say, get riled up, nepotism, crazy idea, salaries not fair, he didn't do a good job. But when you start going there, just please remember this. There are all kinds of prejudice that has flown throughout the history of our country for many different reasons. Please don't be guided by that type of prejudice, but look at the facts objectively and say, did the state present us the whole story, or did they just give us slivers enough to get to you to support their conclusion? And did the investigation seek the truth or evidence to just support the conclusion that they wanted? How did this all start anyway? Do we know? Again, you heard evidence about the Shockley file being damaged in Caswell County. Jay Stoltz told you about the renovations and the flood. You've heard about the key card entries. You've heard about the Melinda Richardson interaction with Cindy Blitzer. And how about this? One of the felony obstruction is that I fired Debbie Holbrook for cooperating with the SBI and impeding their investigation on January 11th, 2017. What evidence have you heard of that other than Craig Blitzer signing an affidavit for a civil case? In fact, I know the details wear you out, so I'm going to say this and move on. When the SBI interviewed him, he told them about a couple of phone calls with me. He didn't say that Debbie Holbrook was fired for talking to the SBI. But later, when he talked to civil lawyers, he said she was fired for talking to the SBI. So where's Debbie Holbrook? And what did she do to help the investigation? And what statement did she make? And why was she let go? I understand that when you came to hear defense evidence, part of you wanted to say, hey, I would like to hear the rest of the story. But the defendant does not have to prove his innocence. The state must prove to you what happened. And they didn't. They just wanted to throw enough to get you concerned, and maybe you'll vote guilty anyway. So what evidence did you get on that felony? Gail Peed said she was present when Ms. Holbrook was terminated. Ms. Peed said she went to Castle when I started as chief with the files issue and that there was an audit. Tyler Henderson told you he was trying to implement digital discovery. Ms. Peed told you that Ms. Holbrook was moved back to Person County and was done training in digital discovery. Jay Stoltz told you part of my job at the beginning of 2016 was to get them on digital discovery, and I didn't get it done. Beyond that, you have Craig Blitzer making a statement of something I allegedly said. And when he talked to the SBI, he didn't even tell them then. It's true. If you believe all that Craig and Cindy Blitzer said, there's not 4 weeks of evidence I could put on to change your mind. But these are the same folks that during the spring, when supposedly Cindy was not working, and supposedly Craig Blitzer said, I said, just concentrate on your schoolwork, that they were arguing. He found out she had a $7,500, $100,000 loan. They were talking about getting divorced. They needed the money. They needed work. Back to reason and common sense. All of you are workers. If you had a job that you could work at the courthouse or at home, and you didn't have work, what does the normal person do? Say once to her husband, will you ask Mr. Bradsher if I could have some work? Or would you call, get in the car, go to the DA's office, say, I don't have any work to do? Now, no, believe me, from a management standpoint, there's no way that I can contend to you that this is a situation that should be duplicated. It should not. In fact, the state ethics rules in the beginning seem unfair because the people of the district elected me. Pam and I were hardworking. Why should this rule exist where she couldn't work with me when there was no problem and the legislature had excluded themselves from this law? Well, I can tell you this. I know.
Objection.
Overruled.
It is true that this ethics law should exist as demonstrated by the conduct of Craig and Cindy Blitzer. That's what it's there to protect the people of the state of North Carolina from. And the evidence clearly showed, as a hiring authority, as a manager, I failed. I failed. And I said it during the examination. Ultimately, the failure of this management issue falls on me. Any of my staff that may have made a mistake or not remembered, for example, you've heard from Ms. Tant that all these hours that were being put in by Ms. Blitzer would have been going to Jay Stoltz into this system where they would check, or a reminder email, and all this going on, and he's running for district court judge. That is not his fault. That is a management fault. But ladies and gentlemen, it was not felonious criminal conduct with intent to defraud the state of North Carolina out of money. Think about it. People that sign off on Beacon all across the state of North Carolina, if those supervisors performing that administrative function were going to be charged with felony obtaining property by false pretenses because someone who put their hours in there didn't actually work the hours that they put in, build a new courthouse. That administratively was a failure, but from the top down, think about it. From the very beginning in 2011, AOC, who runs all of the courts in North Carolina, said I could hire my wife. And for 4 years, with all the safeguards and judges and everybody rotating in, that never gets picked up by anybody. And then with the start of the second term, it's finally picked up. And then all of a sudden, well, that's the law. Sorry. Ms. Wiggins told you. I've told judges they got to pay $20,000 back. It happens. It is true. The attempt to make this switch for this temporary time period while the Ethics Commission was looking at the proposal was novel. But when it came back that the district attorney could not employ the family member that's working in the office because of this ultimate authority over all employment-related activity, Pam went to another job. And you've heard repeatedly from Cindy, she had one course to get. Now I want you to think about this. If the SBI had come in April or August and said, there's all this stuff going on in Rockingham, or allegations that Craig Blitzer is asking employees to take courses for his wife on state computers during state time, I think the evidence would indicate I would have looked at things a lot differently. But in that time frame, please, as jurors, look at it from this perspective. This comes in August when I have a chief in a contested, contentious district court judge's race. And the evidence says that while that race is going on, just out of the blue, SBI says somebody has filed a complaint that Cindy Blitzer's not working the hours she's putting in. Seemed curious. So they don't say, by the way, we're talking to all these folks in Rockingham about all these other things going on in Rockingham. You should not trust what Cindy Blitzer or Craig Blitzer say to you. Instead, they stay on that path. So the state's evidence has been some emails, the ethics policy, the personnel file, the beacon, the requester letter, and phone records. of Craig Blitzer. And they rest. And this is what they want you give it to me. Between April 1st and October 24th, that I feloniously conspired with Craig Blitzer and Cindy Blitzer to commit the felony of obtaining property by false pretenses between April 1st and October 24th. Conspiracy is to enter into an agreement to commit the criminal act of felonious obtaining property by false pretenses. What was my motive for that allegation? When was this agreement supposedly made? Would the state actually argue to you that in the car, Craig Blitzer's saying she doesn't have any work to do, and the allegation that I said, oh, don't worry about it? Is that the meeting that created an agreement to commit a felony? I contend to you that is insufficient. Second, that I committed the act of obtaining property by false pretenses during the same time period, and another obtaining property by false pretenses under the acting in concert theory. Can the state convince you of that when they don't put on all this other evidence? Let me show you this. Agent Whitley, if you remember, the prosecutor asked Tyler Henderson. So you didn't interview him on the 6th because Mr. Bradsher didn't give you his name because he wasn't one he was listed as working. Under oath, agent said, that's right. Then on cross, I said, but I told you he was working with Cindy on the Shockley case. Yeah. And you had talked to 2 other folks from Rockingham and already heard about the shared employee program. Is that right? Yes. You knew Tyler was a part of the counterpart with Cindy? Yes. So it wasn't that he wasn't on the list. That was planned, an investigative path, not to interview him. Yeah, that's right. Take a break. Be direct. Now back, Agent Whitley, about that talking to Tyler, that wasn't really the reason why. Actually, there was some federal interest that started, and then that ended. And then you interviewed Tyler because of that. Oh yeah, that's right. Is that okay? How many times have you heard the stories change by folks on the stand under oath, like Craig Blitzer? When I crossed him about King, who was his confidant, who he talked about these courses with and these other things, immediately, did you see him go on fire? He said, oh, he's got problems with the bar, and, can't believe that. And then he said, it doesn't take much motivation. Craig Blitzer said that. He said, doesn't take much motivation to change your story, and the SBI is coming. In jury selection, I asked you, had you ever had somebody say something about you that wasn't true? You all kind of acknowledged that. How do you combat that? How do you take a Craig Blitzer who said he knew about an investigation in December 2015, March, June, throughout, and then when he finds out there's an investigation, gets a lawyer and doesn't talk to the SBI, and sends a lawyer to his DA staff and says, you can talk to him or you cannot talk to him. It's up to you. And you heard the testimony. When he heard one of the people were saying you needed to talk to him, remember WTF? WTF. Why is she saying that? Call and tell her you don't have to talk to the SBI. Did you hear anything like that in District 9A? Or did you hear, talk to anybody you want to talk to? And they go talk to Jay Stoltz, Gail Peed, Luann Martin, Holly McAdams, Debbie Holbrook. So does the defense have to put on that evidence, or is it the state's burden to prove to you the truth of what's going on here? If there's truly presumption of the innocence, why would they not put on all these other people? For example, Debbie Holbrook called the SBI agent the day after she was let go and talked to the agent. You heard it elicited as to the reason of the termination. What did she say? State didn't tell you. But yet they are going to ask you in a few minutes, vote guilty. Wallace Bradsher must have fired her because she was cooperating with the SBI because Craig Blitzer said so. Believe him. The person who tells you under oath that he had a lawyer this whole time, knew about an SBI investigation this whole time, but did you hear this? Never told his wife. Can you believe that? That he never told Cindy Blitzer that he thought that there was an SBI investigation? Now there's no question there was contact between me and Craig Blitzer. In fact, they brought out a October 18th phone call. There's actually 2 or 3 other phone calls. It's in evidence. The agent said that we had this conversation on the second interview. I talked to 3 elected DAs, told him that. Talked to my resident Superior Court judge, told him that. And the most I could get out was, didn't I express to you concerns about the investigation? Yes. Do you remember the specifics of that? No. This is someone investigating the case, the same person who has decided not to test a computer that may have exculpatory evidence. Ladies and gentlemen, before I shift gears, I just want to ask you this. Is that the justice system that we want in America? Where law enforcement takes down half the story and things that are helpful to the defense you don't write down, and physical evidence that should be tested is not tested because it might undermine the credibility of a witness. Is that where we are? Because if it is, I contend that goes against the very Constitution that I'm being accused of violating as the district attorney. Mr. Latour is going to say, duty, he had to uphold the Constitution and the laws, and that is true, but not just the ones that Mr. Latour wants to talk about, all of them. All of them. And I chose, right or wrong, the evidence shows, to continue to trust the representations of Cindy and Craig Blitzer. even wrote a letter of reference as she left. Until when? She gave a statement early May 2017. And as I said in the examination with Jay Stoltz, I left the DA's office. Because regardless of the misrepresentations, regardless of what had been said to me and represented in their employment capacity, I had failed. Because she said she didn't work. You know, in each prosecutorial district throughout the state, district attorneys can do amazing, great things, not only prosecuting and keeping our community safe, but community outreach programs and deferment programs, etc. But in the end, it seems like we look at the failure. This was an administrative failure that I contend to you, not an intentional criminal act to commit a felony, to defraud the state out of anything. And as you consider that in your heart, what was my motive to do that? I mean, Cindy and Craig Blitzer got paychecks. They went home every night and clearly knew when she was working and when she was not. And unfortunately, my team had to bear the consequences. Tyler Henderson, you've heard from testimony, Iraqi war veteran, subjected to his law school records, GI Bill, financial aid, seized, and then get subjected to this attempt to question him. And then again, when you hear evidence, does the state start with that? Do you remember how it was presented to you? Not all that. It started with, and Tyler Henderson would not submit himself for questioning. This is the verdict sheet. After you hear Mr. Latour's argument, you're going to be asked, first given the law by the judge, and then given a verdict sheet, where you'll go through 7 charges. The first, I've talked to you about conspiracy, that there was an agreement to commit felony, obtaining property by false pretenses. And then 2 more property-related crimes. Next, felonious obstruction of justice. This is related to the Jay Stoltz meeting, August 15th. The next obstruction, the meeting with Agent Whitley on the 6th. And finally, the one that you have almost no evidence on, the obstruction of terminating Debbie Holbrook. I need to talk to you briefly about those factual allegations. So, Jay Stoltz is now a judge. I won't get into the specifics of the politics other than you heard that there was a political campaign going on. So I want you to think about it as if this was happening in your workplace. Jay's running for judge. He hears that this SBI looking into whether Cindy's working. You heard him on the stand. He said he thought it was an administrative inquiry. He's trying to go to court, rotate to avoid this other judge. You heard media comes to Caswell County on October 6th. You heard news reporters were coming to confidential SBI interviews. You heard there was concern expressed to Agent Whitley from me about media, confidential investigation, and other specifics he could not recall from our October 19th meeting. But through all that, Jay wins. Good man becomes judge. And in the midst of all this, he tells you that I call him into my office on August 15th. And the allegations that the state alleged from that event was that I provided false and inaccurate information to Jay Stoltz, an employee of District 9A, causing him to approve and transmit to the state of North Carolina 6 months of false and unsubstantiated time records for Cindy Blitzer. What is the evidence that it was false and unsubstantiated time? Cindy Blitzer, right? Is there any other evidence that it was false or unsubstantiated time? Craig Blitzer. Anything else? The state wants you to assume that she did not do work. Did they present to you other evidence during this time period? Or do they just want you to take that leap and say, it must be true because Cindy and Craig said so? Agent Whitley told you that when I first met with Cindy Blitzer from my interview, that I said, you are responsible for documenting your hours and are expected to work 40 hours a week. Have you heard any evidence from any official that said you cannot rely on the representations of the employee? Oh, I know they want you to believe Cindy Blitzer now because she's supporting their position. When did that happen? After the SBI came in and talked to Rockingham County DA's office? After November, December, January, February, March, April, and May, with the benefit of counsel, and all that time for her and Craig to come up with the story that fit, that helped the state. I asked Judge Stoltz, you remember talking to the officer, the agent, on the 9th? He said he did. And I said, do you remember saying April 12th initially getting a phone call? And he said he didn't. And I asked, have you looked at the statement lately? And he said, well, I have seen the statement, but I didn't get a chance to go back and talk to Agent Whitley. I ask you this, because if I have the burden of proving my innocence, if that's the law that's followed, then you'll just believe whatever the state put up. My question is, have you seen Jay Stoltz's statement that he gave on the 9th? Have you seen anybody's statement that they gave? Have you heard from Debbie Holbrook? Have you heard from Melinda Richardson? They want you to believe that I didn't do my job. So to refresh your memory, I'll read to you from Defendant's Exhibit 2 when I asked for the change in allocation at the beginning of the second term. The current investigator suffered a stroke and is unable to perform the duties of that position. However, he is requested to serve as a VWLA with light duty consistent with his abilities. I'm restructuring Superior Court VWLA position and taking 40% of those duties and combining with the DA investigator duties. Ms. Bradsher will be doing all of the duties of the DA investigator plus 40% of the previously assigned Superior Court VWLA duties, such as grand jury indictment preparation, coordination of officers for grand jury, discovery preparation, victim interviews, etc. Our office has never really recovered from losing 40% of our VWLA staff in 2011 because of state budget cuts. Therefore, in 2011, after the cuts and based on relative volume of cases between Person and Caswell County, I assigned 1 VWLA to Caswell County and 2 to Person County, and it goes on and on and on. I offer to you as the jury, does that sound like a DA that is not involved and doesn't care and isn't checking on his employees? Does it? They want you to presume not. They want you to presume that I had some deal with Mr. Blitzer where Cindy Blitzer just couldn't work. But the law says you must presume innocence and ask, where is the evidence to prove that? Jay Stoltz did approve Beacon for Cindy Blitzer from the beginning, all the way to the point of that misunderstanding. I think March 23rd is the last time he approved. He and I did meet in August of 2016 with regards to these hours. The state very narrowly asked a few questions about that and did not give you his full statement. And they want you to assume that as I directed Jay Stoltz that I did something illegal. You've seen Jay Stoltz. You've heard Jay Stoltz. Do you think he would do something illegal based on his testimony? They next say that I gave false information to Agent Whitley. What was false? I won't go back to it all now, but I did question Agent Whitley quite thoroughly. And I handed you my notes and my statement. Did you compare the two? Did you look at both? Did you see anything that was false? I did contest with Agent Whitley certain things that he wrote down. For example, that AOC had approved the shared employee program. That wasn't true. And when you saw the notes, it was over on the side. Finally, I won't belabor the point, but do you recall evidence that I terminated Debbie Holbrook cooperating with an investigation of the North Carolina State Bureau of Investigation of a criminal fraud with the intent to punish her for said cooperation and deter her and other employees of said office from cooperating with the investigation, thereby impeding, delaying, and obstructing the investigation and legal and public justice? Do you remember any evidence about that other than what Craig Blitzer said? No citizen can prove a negative. No citizen can face a lie of Craig and Cindy Blitzer and disprove it. The real question is, will you allow the state to present part of the picture to you and then convict somebody of a felony? There is a duty as a district attorney to seek justice and as an employer. And the state has presented to you Craig and Cindy Blitzer to convince you that I violated that duty. Where is your heart right now? Will I get the benefit of every reasonable doubt based on reason and common sense? You saw Gail P. She was my AA. You saw the type of employee she was, her honesty, her her veracity, and she told you something very important. She said that we did not approve Cindy Blitzer's time from the time Jay Stoltz had approved it. She told you about an email that she received from Shannon Mears and the response from our office concerning this time. I asked Debbie Tan about that, and she said, if it exists. Gail Peed said, it exists. Did the state give you that? In fact, Debbie Tant said this. So that's the way it was all the way back to 1980. Employees received their paycheck regardless of whether they had entered their time worked or their leave taken. So think about this for a second. 3 of the charges I face are obtaining property by false pretenses based on the employee entering the beacon time. And yet Debbie Tant says, even if they don't enter the beacon time, they get paid. One of the elements on obtaining property by false pretenses is that the false pretense causes the collection of the property. And from Ms. Tant's testimony, it does not. Investigative assistance in North Carolina. The statute says the duties of an investigator.
Objection. You're reading from North Carolina law.
North Carolina statute. Yes.
I'll allow the reading of North Carolina law.
North Carolina General Statute 7A-69. It shall be the duty of the investigatorial assistant to investigate cases preparatory to trial and to perform such other duties as may be assigned by the district attorney. The investigatorial assistant is entitled to reimbursement for his or her subsistence. So the duties of an investigator are cases preparatory for trial and other duties assigned by the DA. I'll read you a couple areas of law and then I'll sit down. I'm sure I'm close to my time. The judge will tell you the defendant has entered a plea of not guilty. The fact that the defendant has been charged is no evidence of guilt. Under our system of justice, when a defendant pleads not guilty, the defendant is not required to prove the defendant's innocence. The defendant is presumed to be innocent. The state must prove to you that the defendant is guilty beyond a reasonable doubt. So the state's theory is this: that Cindy Blitzer worked every hour she recorded until mid-March 2016. Do you believe that? State's theory is from the time I took the Shockley file, she didn't work at all. Do you believe that? State's theory is that one time I told Craig Blitzer she could focus on her schoolwork and not work. Do you believe that? And the state contends that in August, when I learned of this inquiry, that I should not have believed my employee, that I should not have contacted my employee. that I should not have reached out to Craig Blitzer to confirm if she was working, that I should not have talked to 3 other elected DAs to see what the duties are to employees during this investigation, that I should not have given Cindy Blitzer a reasonable time to produce proof to me that she was working, and that by giving her until October 24th and then letting her go, that I must be involved in a cover-up. Do you believe that on a phone call I said I wanted them to lie when they offered to resign, and then 6 days later I let her go? Does that make sense? That she would offer to resign and 6 days later she's let go? Reasonable doubt is a doubt based on reason and common sense, arising out of some or all of the evidence that has been presented, or lack or insufficiency of the evidence, as the case may be. Proof beyond a reasonable doubt is proof that fully satisfies or entirely convinces you of the defendant's guilt. I cannot tell you why the SBI took Judge Crosswhite's letter and revised it from a Cindy Blitzer investigation to include Jay Stoltz and me. I brought it up, but the state never put on evidence to explain that conversation. I cannot explain why I was not contacted when there were allegations that she wasn't working. I cannot explain to you why there was this effort and attack on my office and a presumption of guilt on my part, as opposed to seeking my cooperation. I can explain why Cindy and Craig Blitzer didn't speak to the police and hid behind a lawyer until May of 2017. They played it just right to get their story straight so that they would escape any type of liability. Put it on me. The consequences of your verdict will be upon me and my family. I took the 12 of you as the first folks in the box. I didn't go through the questioning and pick and choose and get the perfect jury pool, because you are the perfect jury pool. You're 12 citizens sitting in judgment of the facts. I appeal to you. Look at what makes sense. Please presume that Pam and I work and that our office is credible and that we did the best we could do under the circumstances, and that I did not intend to commit a criminal offense while in my office. I do concede I failed from a management standpoint, and I left that office. But I started this argument with this, and I'm going to end it with this. All across North Carolina, we cannot continue to have people from young to old convicted of crimes when cases are investigated like this, and the state doesn't put out the whole story, but instead gives you a sliver. This case is about the duty of a DA. I don't know if you know this, but I know Mr. Latour does. Our duty is not just to convict and prosecute cases. It is to seek justice And sometimes that means giving people the benefit of the doubt, like Cindy Blitzer, when somebody is alleging she's doing something wrong, even though later you get burned because she wasn't being honest. Do we make mistakes from the heart, trying to do the right thing? Or do we step back and protect ourselves? And regardless of the consequences to other people, we're just going to do what protects us. I am standing in front of 12, 15 people in Wake County. This isn't my home. And all I can do is appeal to you that when you apply the principles that we've talked about and search your heart and pray, I pray that you will find the truth and that you will let your verdict speak the truth, and that my actions were not an intentional criminal event, but rather a failure from the heart, trying to do everything from trying cases to managing employees to implementing a new statewide digital system to make things better. Because what was most important to our office was that we try to seek justice and do the right thing and make things better. And out of those 100 efforts to do that, I did have this failure. And I pray that you will not find it as a criminal failure, but a human one. Out of love for that very oath that Mr. Latour is getting ready to talk about. A love for this state and this country. I'm sorry for the failure, but I'm not sorry for standing before you and telling you.
Objection.
Mr. Bradsher,
I'll wrap up, Your Honor.
yes. You know the rules, sir.
Yes, sir. I'm standing before you and asking you to look at the evidence and give me the benefit of every reasonable doubt. I did take that oath, and I did it to the best of my ability. Thank you.